Hello, everybody. Thank you for joining this seminar. I've got 20 minutes, and it's not my intention in 20 minutes to cover the entire topic of restrictive covenants. I'm going to speak specifically about the interpretation of covenants that prohibit some activity without someone's consent. Now, even so, I've given myself quite a lot to get through in 20 minutes, so if anybody has any questions, then do send them in and I'll deal with them at the end so that anybody who needs to get away can do. First of all, by way of brief revision, the BBC of restrictive covenants. This is something that you have to look at whenever you're faced with a restrictive covenant case. The B, and C, benefit, burden and construction. This talk is going to be about the C, construction or interpretation. But first of all, looking at the other two, benefit first of all, this is something you always need to consider, which is whether the land owned by the person who wants to enforce the covenant has the benefit of that covenant. And generally speaking, that will be because the person seeking to enforce the covenant is the original covenantee, is the owner of land to which the covenant is annexed, is an assignee of the benefit of the covenant, or is the owner of other land included within a building scheme. Now, I've not got time to deal with those this morning, but the reason that I mention it is that it sometimes can throw up an odd situation where the person who has the benefit of the covenant and the person who has to give the consent may not be the same person. So just to give a simple example, if we've got a covenant not to build without the consent of Mrs. A, now that might be annexed to the land of Mrs. A. Mrs. A sells her land to Mr. B, and what that can mean is that Mr. B has the benefit of a covenant prohibiting building without the consent of Mrs. A. And we'll see later that can lead to a slightly odd situation. Burden, very quickly, is the land owned by the person against whom the covenant is to be enforced, burdened by the covenant. And I think for now it suffices to say that this will either be because he's owned by the original covenantor or the subsequent owner of land against which the covenant has been properly registered. And then on to the main subject matter. What does the covenant mean? Now, the starting point is that covenants are to be construed in the same way as other contractual documents. And I'm sure you'll all be aware of the Supreme Court trilogy of cases, Rainy Sky, Arnold and Britton, and Wood and Capita, which set out the rules for construction of contractual documents. There are two slight qualifications in the case of restrictive covenants. The first is that there will be less emphasis on surrounding circumstances. And this is because, as many of you will know, you are often asked to interpret a covenant many years after it's been given, in circumstances where the original parties have died a long time ago, and the physical nature of the site may well have changed as well. Now, the case of Bryant Homes and Stein Management Limited, that was a case where the issue was whether a side agreement between the parties could be prayed in aid when interpreting a restrictive covenant. Now, applying the usual test from the trilogy I spoke of a moment ago, that side agreement was information reasonably available to those in the position of the contracting parties at the time when the covenant was given. So you would think that that would be material which would be relevant when seeking to construe the covenant. But the way the court dealt with it is saying that the information reasonably available to the original contracting parties included the fact that the covenant may be construed many years later, and included the fact that the original covenantor and the original covenantee, who would have been the only people aware of the side agreement, might well be long gone. And they were also aware of the fact that the document was to have the same meaning for original parties and successors, and therefore, on the facts of that case, the side agreement was not admissible when seeking to construe the covenant. The second qualification is that we often hear it being said that that when you're interpreting contractual terms, don't look at previous authorities because it all depends upon the circumstances of your particular case and so forth. But with restricted covenants, there is an aspiration that words will have the same meaning in different cases to promote certainty. Because often restricted covenants are something somebody might look at when they're thinking of buying a property, and they really need to be able to know what it means fairly easily without coming and taking advice on it. And so in the well-known restricted covenant case of Crest Nicholson, Mr. Justice Neuberger said, it's not illegitimate to bear in mind the desirability of certainty and consistency. That it is desirable for people to know with reasonable certainty what their rights may be. Uncertainty breeds costs, worry and litigation. A relevant example here, one issue we'll deal with in due course is, if the covenant requires the transferor's consent, does that mean just the transferor, or if the transferor has sold on, does it include his or her successor? And that's an area where there's great advantage in it being the same in every case. Now, finally, before we come on to prohibition on doing things without consent, beware the absolute covenant. And an example of that is a simple covenant which prohibits the building of more than one house on a plot of land. And that doesn't matter how sensible, how reasonable it might be to build two houses. If that's what the covenant says, that's what the covenant means. And those who enforce the covenant can just say no if you ask them if you can build a second house. And other than paying them off, your only other option really is to go to the upper tribunal to try and get the covenant modified and discharged. And again, that's a matter for another talk on another day. So the prohibition on doing things without consent, which is the main topic of this talk. There are three main questions. The first is, who has to give the consent? Secondly, on what basis can they refuse the consent? And thirdly, what happens if they aren't around anymore to give the consent? And normally because the individual has died or a company might have been dissolved. Who has to give the consent? Is usually one of three candidates named in the transfer or the conveyance: a named individual, the vendor stroke the transferor, or the owner of a named estate. And so we're going to give you a worked example and try and remember who all the characters are for later on. The local landowner is Lord Bigtoff, who lives in a manor house which is just off this picture. In the bottom left-hand corner, you can see a house. Lord Bigtoff has sold this house to Mrs. Fish, imposing a covenant not to build something without the consent of somebody who we'll discuss shortly. This is the same land a few years later. Lord Bigtoff has since developed and sold off 30 houses, and the purchasers include Mr. Disinterested, Miss Reasonable, and Dr. Awkward. Lord Bigtoff then sells up what remains, his manor house and his remaining land, to Mr. New Money and retires to Scotland, and then in due course he dies. Mrs. Fish wants to build an indoor swimming pool complex, and she sees that she can't do that without someone's consent. And she comes to you saying, whose consent do I require, and what's the basis upon which they can give or not give that consent? And to recall the previous slide of the three candidates who will probably have to give the consent. Now, in named individual cases, you might have a situation not to construct any building without the consent of Lord Bigtoff. That's the case. There's no doubt who has to give the consent. You can't construct without the consent of Lord Bigtoff. And that's fine if Lord Bigtoff still lives in the manor. But if he's moved to Scotland, this leads to an odd situation that we talked about earlier. So assume that the benefit of the covenant is annexed to the land owned by Lord Bigtoff when he sold the house to Mrs. Fish. That means that Mr. New Money and all the owners of the houses on the new estate, including Mr. Disinterested, Miss Reasonable and Dr. Awkward, have the benefit of the covenant. But despite Lord Bigtoff not being there anymore, he can say, build what you like, because he's the person who has to give the consent. The other problem, of course, is if he died, there's nobody in the named in the covenant who can actually give the consent. And we'll discuss the implications of that a little bit later. In the vendor or transferor cases, you look for the definition of the that's where the consent has to be given by the vendor or the transferor. First thing to do is look for the definition of the vendor or the transferor, and you'll find that in box 4 of a standard TR1 or generally in the heading of a conveyance. Often it will simply be defined as, in this case, Lord Bigtoff. But check there's nothing else to expand the definition somewhere else in the conveyance. For instance, a clause elsewhere saying that the term will include successors in title. Now, if the vendor or transferor is a named individual in the transfer and nothing more, it's that individual that has to give the consent. And that gives rise to the problems that we discussed, as if it had simply referred to Lord Bigtoff. Is there a way around that? Well, we had a clever answer in this case of Mahon and Sims, a case of Mr. Justice Hart, who is probably one of the few Chancery judges who had an obituary in the Independent which described him as a subversive. Now he wasn't impressed in this case with the argument that the clause defining the transferor was indeed a clause defining the transferor. And you'll see what he said. It is not, however, itself a defined expression to any greater extent than that it is itself the term used by the transfer to describe the Boltons. I don't understand that, frankly. And then he also said, if you look at Section 78 of the Law of Property Act, a covenant relating to land is deemed to be made with the covenantee and his successors in title. What he was clearly trying to achieve was the objective that the person giving the consent was the owner from time to time of the land with the benefit of the covenant. Now there are two problems with that. The first is a practical one. It's okay if Lord Bigtoff has sold on to one person, that person has to give the consent. But of course he's sold to all the homeowners on the new estate. And therefore, you could end up with a situation where you have to get unanimous consent from a committee of 30 plus that has never met. You might get it from Miss Reasonable. Mr. Disinterested would simply ignore the correspondence, and Dr. Awkward would say no, however reasonable the plan was. So in trying to get rid of one issue, you've created another one. The second problem is perhaps one for the purists. If the covenant is with a covenantee and his successors in title, that would logically mean that all of them, the original covenantee and all the successors in title down the chain, would have to give consent. Now, you won't find the answer to this conundrum in Mahon itself. This simply wasn't addressed. It's not even clear whether these points were even argued. But you'll find plenty of cases which go the other way. First of these significant ones is City Inn. It was followed in several subsequent court cases, and this is just a few. And then also for good measure in the upper tribunal when considering applications to modify or discharge covenants. I've not got time to go through all those cases, but it suffices to say, I think, that logically the approach taken in this long list of cases seems to be right, and a million lemmings can't be wrong. So if the person who has to give the consent is the vendor or the transferor, then the chances are it means just that. Now I turn to cases where the consent is to be given by the vendor, transferor, and successors in title. Now that can be found in the definition of the transferor itself, or often later, as we mentioned a few minutes ago. Two issues: when and who. When, fairly obvious that generally it's the person who is the successor in title at the time when the consent is being given. Who? This is not so easy, and to demonstrate that by reference to the Big Toff estate, it is the problem I discussed a few moments ago. If Lord Big Toff had sold the house to Mrs. Fish and then sold the rest of his estate to Mr. Newmoney, then he would clearly have been the successor in title. He was to give the consent. And in practice, many cases involve a house with the benefit of a covenant that's been sold to somebody else, and it's easy to see who the successors are. But we know that Lord Big Toff sold off 30 individual houses before he sold up to Mr. Newmoney, and we've got 31 successors in title. So is it just Mr. Newmoney that has to give consent, or all of them? And if it's all of them, we've got problems. One way round it in a very old case is that if the Big Toff estate is still recognisable as such, even though some parts have been sold off, the chances are that it's the owner of what is left of that estate that may have to give the consent. But each is going to turn on its own facts, and there will be a degree of common sense. You've identified who has to give the consent, but on what basis can they withhold it? Three issues to consider here. The express terms, the implied terms, and the effect of those terms. Express terms, some of them will tell us that the consent is not to be unreasonably withheld. It's not as usual to see it in freehold restricted covenants as it is in leasehold covenants. But if the express terms don't cover it, would a term be implied, and if so, what? As you'll all be aware, it's increasingly difficult to imply a term into a detailed written contract. You need to show that without it, the contract would lack commercial or practical coherence. Two reasons why it might. Example given in the case of Rickman and Brudenell Bruce, covenant against building anything other than the existing bungalow without consent. And the court used the example, if it burnt down and had to be replaced, if no term is to be implied, then the rebuild could be thwarted altogether. Or consent could be refused for reasons which are completely arbitrary. So Dr. Awkward said, I'm not giving consent because your daughter was rude to my son at school, or something of that nature. So there is an argument that a term should be implied, but what is it? Should it be the consent cannot be unreasonably withheld, which is the most common express term? Or Should it be something based upon the Supreme Court decision in Braganza? Now, some of you may be aware of this case. It's well outside the scope of restricted covenants, but it's a case which shows what term will be implied when somebody has a contractual discretion to exercise. And it aligns the law on that with the law that applies to public authorities when making a decision. So many of you from student days, if you don't do administrative law, will remember the Wednesbury concept of unreasonableness. It's not a question of whether the person's being unreasonable, whether they're being so unreasonable that no reasonable person properly directing their mind could have come to that conclusion. And that will be so if the reasons are wholly irrational or have absolutely nothing to do with the covenant, and the child being rude being a good example of that. Nobody has yet said that this is the absolute way forward with restrictive covenants. But the tide is moving that way. It's been held to apply in cases involving consents under leases, the West India Key case, and in a slightly different context, in a restrictive covenant case, in the Warwickshire College case. And it seems to me that it's almost inevitable that this is going to be the approach going forward. So, 3 key points, I think, to make in relation to withholding of consent. You can't refuse consent for a basis that has nothing to do with the covenant. You can refuse consent even if most people would think that that decision was unreasonable. But you can't do so if it's outside the band where somebody acting rationally could think that the decision was reasonable. Moving on now, and I'm sorry I'm overrunning slightly, to death or dissolution. Literal interpretation, not to build without the consent of the transferor, or not to build without the consent of Lord Bigtoff. Lord Bigtoff has died, no transferor, so we've got no consent. No consent, can't build. And that was the approach taken in a number of the earlier cases. I've listed just 3 there. The sea change came in the Crest-Nicholson case, where Mr. Justice Neuberger said, approval exception was so fundamental to the restriction that if the exception was discharged, then the restriction was discharged with it. Or if necessary, he would have reached the same conclusion by implication of a term to that effect. In other words, if the person required to give the consent has died, the covenant goes, it doesn't become absolute. And since then, there has been the odd outlier that this is the approach that's been taken both by the court, and I give 2 examples there, and by the upper tribunal dealing with applications to modify covenants. And finally, a word about the upper tribunal. Many of you will be aware that the upper tribunal has a discretion to modify or discharge restrictive covenants on various grounds, including the ground that the covenant has become obsolete, or because everybody agrees to the discharge of the covenant. Now, for many people, that second one's not particularly clear because they think, well, if everybody agrees, why do you need to go to the tribunal? And that may be a help in a restricted covenant case to deal with people like Mr. Disinterested. Because if there's a request and nobody answers it, then anybody who does not respond to an application to discharge a covenant is deemed to have agreed to that modification or discharge. So sometimes you could use that as a way to deal with a situation where nobody is actually agreeing to, or somebody is not agreeing to the discharge of the covenant. Or if it's an unusual case where the covenant has for some reason become absolute because somebody's died. According to Preston and Newsom, it might or it might not be considered obsolete depending on the facts of the case, which is extremely helpful. And I'll end this talk with that note of clarity. I'm going to now finish this talk. I see I've got one question, which for those of you that want to stay, I will now answer that question. But thank you very much for attending. So the question is, if consent is required from Mrs. A or the registered owner of the benefiting land, can the consent be obtained from A only, where she is no longer the registered owner of the benefiting land? Now, I think the answer to that, it depends on how that particular covenant is construed. So if it is intended to, if on a proper construction, you end up with it being you can have your consent from one person or the other, then yes, you could get the consent from Mrs. A. I think the more likely interpretation to give business efficacy to the covenant is that where it's talking about the owner or successors in title, I think the general aim of that would be to say that it is the owner, unless there is a successor in title, in which case it would be the successor in title. And that would tend to accord with the purpose of the covenant, which would be to ensure that whoever owns the benefiting land at the time the request was made is the person who is going to give the consent. So I think that answers that question. I haven't got any other questions on the screen, but if anybody thinks of anything later on, then by all means, give me a call or drop me an email and I'll try and answer it. But thank you very much, all of you, for attending.